Okay, hello everyone. We had some technical difficulty. Hopefully this time you can see the video. Yeah, we are live. Yeah. So sorry about the technical glitch. Welcome back to another Patexia IP Matters webinar. Today joining us Matt Phillips and Kevin Laurence from Renaissance IP Law Group. I'm gonna quickly go over the introduction, and because we're a little bit behind, I'll pass it to Kevin and Matt. So both Kevin and Matt, Renaissance IP Law Group. They almost exclusively focus on AIA trial proceedings. They have been counsel collectively in over 60 review proceedings. Matt, based in Portland, is a former Federal Circuit law clerk and has recently completed a series of 6 IPRs in which he successfully defended the same patent. Kevin, based in Washington, D.C., teaches a course on post-grant proceedings as an adjunct professor at the George Washington University Law School. And in fact, Best Lawyers in America named him their 2016 Lawyer of the Year in patent law for Washington, D.C. So together, they teach a 2.5-day course on post-grant proceedings for Patent Resources Group. And their next course will be in Tampa, Florida in April. If you guys have any question, please use Twitter and use the hashtag IPMatters. We will answer the questions at the end of the this webinar. So without further ado, I'll pass it to Matt. Matt, please go ahead.
Okay, thanks, Pedro. So our topic today is PTAB versus district courts, the pros and the cons. We're going to walk you through what well, some of our analysis to decide which forum is better to bring a validity challenge. So on slide 2, we have our agenda. I'll move through the first bullet points very quickly, just a quick review of the tools for challenging patentability, a very quick review of AIA trial procedures. We'll go over just some key statistics briefly, and then we'll spend the bulk of our time discussing the 4th bullet point, which is choosing a forum to challenge validity. Okay, so skipping ahead to slide 4, please. This is our way of looking at the different tools available to challenge pre-AIA patents. Those are patents that have an effective filing date before March 16, 2013. And there are 4 options. In the bottom right corner is litigation. If you find yourself in litigation over a patent, you can challenge its validity on any grounds, any basis, 101, 102, 103, 112. And then there are 3 other options, all at the patent office. On the far right is ex parte reexamination. It is an option for challenging the validity under 102 or 103 if your prior art is in the form of a printed publication. And that is the exact same basis you can bring in an inter-parties review. Covered business method patent review, or CBM, is broader. You can bring any basis, but you only have standing to file a CBM petition if you've been charged with infringement of a covered business method patent. And believe it or not, I've been involved in cases where the same patent has been in all 4 proceedings at the same time. In fact, I've been in 2 such cases. All right, moving ahead to slide 5. This shows the tools currently available to challenge AIA first inventor to file patents. On the ends, on the bottom, litigation, ex parte reexamination are the same. One of the differences here is that inter-parties review and covered business method patent review are only available if the patent is more than 9 months old. During the initial 9-month life of the patent, you can bring a post-grant review, and you can bring that on any basis. Now, slide 6 shows the landscape in 2020 after the CBM proceedings have been phased out. Those are a program that's meant to be an 8-year transitional program, and they sunset in 2020. at which point we'll have options as shown on this diagram. Okay, Kevin, do you want to tell us about AIA trial procedures?
Yes, moving to slide 8, there are two phases to review proceedings. You have the preliminary phase that's kicked off by the filing of the petition, and then you have the trial phase, which begins with the institution decision, and that trial phase is completed when the PTAB issues the final written decision 1 year after the institution decision. After the trial is completed, the appeal is going to take at least a year if there is an appeal, so the total process from start to finish would be about 2.5 years. Now, moving to slide 9, in that preliminary phase, there are two events that occur. One is after the petition is filed, the PTAB accords a filing date to the petition, and that date is used to trigger the 3-month time period that the patent owner has to file a preliminary response. After the patent owner files its preliminary response, then the PTAB has 3 months to issue the decision on whether or not they're going to institute and on what grounds. So moving to slide 10, the trial phase is essentially a ping-pong process, and so each party has an opportunity to conduct discovery of the other party's declarants. So any party, excuse me, any expert witness who files a declaration will be deposed by the opposing party. And this slide shows the key events that occur, and they're color-coded. So the blue is the PTAB, the green is where all the parties are participating, orange is the patent owner, and then red is the petitioner. So the main event for the patent owner after institution is the filing of a response. And in contrast to the preliminary response that was filed prior to institution, the response is filed with declarations from an expert. And so this is really the patent owner's main opportunity to influence the outcome after institution. And the experts that are that filed declarations with that response are then deposed by the petitioner. Then the petitioner files a reply. Now, this particular set of this particular schematic does not show what occurs with a motion to amend. It's a little bit simplified. After the petitioner files the reply, then there's a series of filings that are filings of motions, mainly relates to motions to exclude. And then, as I mentioned earlier, the trial phase is completed with the hearing. And so the hearing is essentially an opportunity for the judges to push and explore the claim constructions that have been proposed by the parties and to understand the references and how they are to be applied. And so critical, but very different from a proceeding in court. Now in slide 11 we have a little bit more detail of the time intervals that are involved. So the patent owner has typically about 2 months to file its response, and if it's going to file a motion to amend, this slide shows the events with the motion to amend. And during that 2-month time period, the patent owner deposes the experts from the petitioner, and then another 2-month time period starts after that where the petitioner is able to depose the patent owner's experts and then file the reply. And if there was a motion to amend that was filed, then the petitioner files an opposition. Then typically there's about a 1-month time period for the patent owner to reply to the opposition to the motion to amend and to depose the petitioner's witness that filed a declaration with the reply. That's without regard to whether or not a motion to amend was filed. And then the due dates 4, 5, and 6 are usually very compressed and relate to the filing of motions to exclude. So I think I may have mentioned that the hearing is usually about at the 7-month mark in the 12-month time period. This is a very compressed schedule. It's even more compressed than what we saw when review proceedings first started. And so the PTAB has got a tremendous workload at which they're handling with aplomb. And but they need 5 months. They're reserving 5 months for themselves to complete the written decision. As you can imagine, that has to be circulated and approved, and so there's a process that's involved that requires a fair amount of time. But the result for the petitioner and the patent owner is that you have to really scramble for all of those deadlines within that 7-month time period.
Yeah, and Kevin, as compressed as the trial schedule is right now, one of the proposals that the PTAB has circulated is allowing patent owners to put in testimonial evidence with the preliminary response, and I'm concerned that that would compress everything even further to the pre-trial stage, and I'm not sure I'm in favor of that, but we'll see if it gains any traction.
Yeah,
now, we know you've been inundated with statistics about AIA trials, and we don't want to add to that unnecessarily, but we do want to point out a few key statistics because of their relevance to our topic. Because the statistics, when you really dig down and understand them, I think demonstrate the effectiveness of the PTAB as a forum to invalidate claims. So if we first look at slide 13, this is just a simple bar chart showing the petition filings by type, by fiscal year. And you can ignore really the two ends, fiscal year 2012 and 2016, because those were partial years. The data for 2012 was really just over a period of a few weeks. And for 2016, we only have data, well, we only included in this chart data for the first quarter of the period. But we have a full year's worth of data for the 3 years in the middle, and the brown bars represent IPR petition filings, the green bars CBM petitions, and the yellow bars PGR petitions. And notice that this is on a logarithmic scale, so the volume of IPR petitions is an order of magnitude greater than CBMs, which is in turn an order of magnitude greater than PGR. So in fiscal year 2015, for example, there were over 1,700 IPR petitions filed, there were about 150 CBM petitions, and there were 11 post-grant review petitions. Now in slide 14, the next slide, there's a pie chart that shows the breakdown by technology for these petitions. Most of the action has been directed at electrical and computer patents, about 62%, but all technologies have been affected by AIA trials, even biopharma patents, and that's a relatively recent phenomenon. Next is the chart on slide 15, which shows how frequently the PTAB institutes trial. As Kevin explains, there is an institution decision, so not all petitions result in a trial. Here, I'd like to focus on the brown bars and the green bars, so IPR and CBM in the complete years, 13, 14, and 15. You notice the downward trend. In 2013, the institution rate for IPRs was almost 90%. Last year, it was under 70%. And it's similar for CBM. There are a lot of reasons for that, and that could be the topic for another webinar. But the significance is it's not as easy to get a trial instituted as it used to be, but there's still a high likelihood that a petition, especially a well-written, well-supported petition, will result in trial being instituted.
Moving to slide 16, this shows the disposition of challenged claims. That it's interesting to see that 57% of the claims that are challenged in an IPR are not subject to trial. So the PTAB is called a death squad, but in reality, more than half of the claims that are challenged don't even get tried. Because the petition requires the petitioner to essentially present its case in chief up front, it does drive settlement, and so you get 13% of the claims being involved in a settlement. And because the case in chief has been presented, the patent owner is very able to assess the merits of their situation, and they cancel a number of claims, 5%, or disclaim them. And then 21% are found to be patentable and 4%, unpatentable, and 4% are found to be patentable. In slide 17, we show the percentage of claims that are subject to trial, and 31% settle. So after you have, if you're the patent owner, you've read the petition, now you've read the institution decision, and you have a pretty clear idea of what the lay of the land is, and that drives a lot of settlements. I think that number is very telling for whether or not review proceedings are achieving their objective of reducing litigation. And then the percentage increases for the number of claims that are canceled or disclaimed. But about half of the claims that are subjected to trial are found to be unpatentable. Only 9% are found to be patentable, and so kudos, Matt, on surviving 6 successive IPRs. That's quite an accomplishment. This next slide, slide 18, that shows the disposition of cases, not claims, but cases after the final written decision. So here you see that 72% of the cases result in a finding that all of the claims are unpatentable. That is significant carnage for the patent owners. And I think that we're going to see a shifting of that number, but I think that presently that number is merited, because in the past we wrote patent applications for survival in the district court, and that was a very different standard than writing for survival at the PTAB. And so when patents start to be challenged that were drafted post-AIA, I think we'll start to see a shift so that this pie chart looks more like the pie chart that you see for European oppositions, which is more evenly divided into thirds, as opposed to this pie chart, which shows 15% of the claims being a mixed bag, and then 13% surviving with no claims being held to be unpatentable.
And Kevin, kudos to you, because I know that you wrote and prosecuted a patent that recently survived an IPR challenge.
Yeah, thank you. That was, it was about 12 years ago that we drafted it. Interestingly, it included a means plus function claim, just one means plus function claim, but that is a topic we could dedicate a whole presentation to another time, perhaps.
Right. Okay, well, with that as a quick background, let's move on to our main topic, which is choosing a forum for challenging validity. On slide 20, we list a number of factors to consider. Really, these are differences or potential differences between the courts on one hand and the PTAB on the other hand. So let's assume the point of view of a challenger as we go through these factors. And let's further assume that you have the type of validity challenge that you could bring in either forum. So, for example, it may be an anticipation or obviousness challenge based on a printed publication. So you have the choice of taking that to the PTAB or the court, and we recognize that sometimes you do both. And then the question really is not so much which one should I do as which one gives me the higher likelihood of succeeding. And here's a list of factors. We're just going to go through them and talk about each one, whether it weighs in favor of going to the court or the PTAB.
So in slide 21, we have the decision maker profile, and the question to ask yourself if you're the challenger is, who's going to be more comfortable invalidating a patent that was granted by the government? A jury is going to be rather reluctant as the patent owner waves around the red ribbon copy of the original patent. They're going to be impressed by that. The judge less so, but the PTAB even less so. They're comfortable overturning examiners 50 to 60% of the time. And because most challenges involve obviousness, asking yourself who is most comfortable assessing obviousness, I think, is probably the most determinative issue that we'll address of all these different factors. And wrapped up into that is the technical acumen of the decision maker. Do you have complex facts? Is it a simple invention in the patent? Would the conclusion be apparent once the facts are properly understood? And clearly, the PTAB with 3 technically trained judges is going to have better skills in that regard than 12 jurors. And another issue is who is going to be more comfortable with legal doctrines like secondary considerations of non-obviousness, the priority entitlement, and then something like inherency. Inherency is particularly problematic for those who are not well versed in patent law, because you essentially have to find that something is in a document that isn't on its face. It can only be there based on practicing the invention based on what's disclosed. Moving to slide 22, there's clear conventional wisdom with regard to litigation that it's better to have an anticipatory reference than to rely on a combination of references and assert that the combination makes the claim obvious. But that conventional wisdom does not carry through to review proceedings. In fact, it's the opposite. Because of that technical acumen of the 3 technically trained judges, they're very comfortable with obviousness. And after KSR, the ability to assert obviousness, the threshold was lowered, and there's quite a bit of flexibility in use of obviousness. And anticipation, on the other hand, requires a rather rigid application. And so if you don't have a reference that truly is dead on, then it becomes problematic at the PTAB. And so if you are stretching in litigation, you definitely shouldn't stretch in front of the PTAB. So that opens up the opportunity to challenge a patent in a way that just isn't there in litigation. And so in slide 23, we have that same position summarized, that 103 trumps 102 as a ground. And we'll briefly mention that an additional reason why 103 trumps 102 is the introduction at the PTAB of a creation called the redundancy doctrine that has been used to filter out grounds. And so if you have a 103 ground and a 102 ground, if the PTAB takes just your 102 ground and it turns out that your 102 didn't quite have what it needed, then you would really have a difficult situation when you could have relied on the more flexible ground under 103. And we also show here that 101 trumps 103. In today's environment, if you have the ability to assert that the claims are invalid under 101, and you can do that in a post-grant review or in a CBM, that'll be your strongest attack.
So what about claim construction? Turning to slide 24. The 2 forums, the PTAB and the court, definitely employ different methodologies to construe or interpret claims. In the PTAB, they use the broadest reasonable interpretation, and that is, as the name suggests, one that favors breadth. Basically, if there's nothing in the intrinsic evidence that includes the specification and the original prosecution history that clearly and unambiguously indicates a narrower meaning, then the terms take their broadest reasonable interpretation as they would be understood by those skilled in the art at the time of the effective filing date. Courts, on the other hand, employ a different methodology. It's based upon the Phillips case from now over 10 years ago. And under the Phillips framework, there are lots of canons of claim construction. And these canons have developed over the years as reasons for courts to narrowly construe claims. For example, one of them has to do with the presence of sentences in the specification that characterize the invention or the present invention. Those can be reasons to take a narrow claim construction, notwithstanding facially broader claim language. And there's nothing like that comparable that comes into effect under the broadest reasonable interpretation, and that's just one example. But because you have all these canons of claim construction, some of them frankly contradictory, it is a less predictable framework. So you have to ask yourself, does the prior art that you depend upon, does it fall within the broadest reasonable meaning of the claims, yet different from the disclosed embodiments? If so, you still may have a viable claim interpretation to support your basis for invalidity at the PTAB under the BRI standard. However, you run the risk in court that a court might take a narrow claim construction more aligned with the disclosed embodiments, and that could exclude your prior art from the scope of the claims. Now, maybe that's not a bad thing. It's bad for your invalidity case, but it may give you the non-infringement argument that you want and can win the case overall. But you need to be aware of that possibility. And in some cases, it really does, I think, make a difference. In many cases, it doesn't make a difference at all. The Phillips construction and the BRI may be exactly the same for a given patent.
And before moving from that topic, we should note that the Supreme Court has accepted a petition for cert in Quozo, where this issue will be addressed. And I think the Phillips decision is widely viewed as being brilliantly written, and who knows what our outcome will be. But that issue is potentially in flux.
Yeah, that's right. We may be applying the Phillips framework in PTAB proceedings in the future, if that's what the Supreme Court says.
Or
Good
the
point.
Quozo standard, whatever that is. Okay, so moving to slide 25 regarding evidentiary burdens. At the PTAB, the PTAB uses the preponderance standard just as the Patent Office uses in all proceedings before it. And that is a lower threshold than what's used in litigation. In litigation, the clear and convincing standard is used. So here again, you ask yourself, which is better between these two? And for the evidentiary burden, some examples that that often come up would be whether or not the issues are so close that that burden might make a difference. For example, is the prior art arguably ambiguous in its disclosure of a claim limitation? If so, then the preponderance standard might be better for you. And another example is if the prior art status of the printed publication is a close question. In other words, if the public availability, for example, of the prior art references in question. And finally, another example, does the outcome turn on disputed, equally reasonable, and supported expert opinions? And if so, the lower threshold of preponderance might be better for you than the higher standard that's used in district court.
Okay, next let's talk about the nature of the supporting evidence that you can present. There are 2 points I want to make. The first is that the federal rules of evidence apply in both forums, but the PTAB applies those rules differently. Specifically, the PTAB rarely excludes evidence. The PTAB, panels are formed of expert judges. They understand how to weigh evidence. There's no jury. There's very little risk of prejudice or confusion. So PTAB judges, when faced with a motion to exclude, are likely to say, no, the motion's denied. We'll give appropriate weight to the evidence rather than exclude it entirely. So that's one difference. The other point I want to make is that in the PTAB, almost all the evidence is on the paper. It's very rare to have live testimony. So testimonial evidence comes in through documents, declarations, and deposition transcripts, and that's it. In court, on the other hand, you can have live testimony. You can have an affable, charismatic witness to bring your position to life through oral testimony. And if that's part of your strategy, if you've got that on your side, then maybe the court is the place you want to be rather than the PTAB, where that witness would basically fall flat on a piece of paper. And I have been involved in one case where this exact issue came up. This was years ago when our choices were between reexamination and court. And we had a great witness. who was the author of the prior art document. He had testified before about this document in another case completely unrelated and successfully explained its relevance to invalidate another patent. And so we made the decision to make our invalidity challenge in court, and it worked out well in that case, but that's definitely a rare occurrence, but something to be aware of nonetheless.
So moving to slide 27, with regard to discovery opportunities and burdens, in court discovery is wide-ranging, and oftentimes the plaintiff is able to develop its case through the discovery process. And as I mentioned, that's the opposite in a PTAB proceeding, where you present your case in chief up front. Part of the reason why PTAB proceedings are able to go so quickly is because discovery is quite limited. You're essentially limited just to deposing the other party's expert witnesses. And you can get additional discovery in certain circumstances, but it's very difficult. You have to essentially be able to point to a smoking gun that allows the PTAB to feel comfortable that you're not going on a fishing expedition. And the PTAB is very focused on keeping its obligation to meet the one-year deadline of issuing the final written decisions 1 year after institution. And so anything that detracts from that, that's not related to a resolution on the merits, is not received in a welcoming way. And so there are issues, though, that are critical to get additional information about. For example, real party and interest is an issue that has emerged because it's statutorily based, that is very productive for a patent owner who has a patent that is difficult to defend and is able to recognize that the petitioner has failed to identify the real parties and interest or privy that should have been identified. But this is an issue that really requires close analysis, because if your case as the potential petitioner in a review proceeding would be hampered by your inability to prove your case because you can't get discovery, then you want to go to litigation, where the discovery is wide-ranging and it's easier to get the information that you need. If you feel that there's a high likelihood that the patent owner would be able to present a compelling case of objective indicia, that's not a situation where you want to make your challenge in district court. There, you're going to really be benefited by the limited discovery that's available in a PTAB proceeding. And Matt and I have both experienced a situation recently where we had fantastic facts for secondary consideration, but the restraints that are presented are just so limiting that even with fantastic facts, it's very difficult. Fortunately, we had compelling substantive reasons other than relying on secondary considerations.
Okay, next. Well, what about participation rights? Well, it really doesn't make a difference. You have full participation rights in both forums, in court and in the PTAB. In the PTAB, you get to file the petition, of course. You get to depose the patent owner's declarants. You get to file a reply to the response filed by the patent owner. You get to attend the oral argument and participate, and you can file objections to evidence and motions. You can fully participate. So there's really no difference. We note this, however, because if re-examination is one of the options you're considering, then that is starkly different. In a re-examination, typically, you as the challenger have no participation rights after filing the request. That's the ex parte nature of ex parte re-examination. So that can make a huge difference, and that is, in fact, one of the reasons why ex parte re-examination is a friendlier environment for patent owners and a more difficult forum or type of proceeding for challengers.
So moving to slide 29, and it's important to assess whether or not the whether or not it's important for you as the challenger to be in a forum where the claims are frozen or fluid. Of course, claims are frozen in court, and claims are quite fluid in re-examination. It's very common for the patent owner to emerge from a re-examination with an enormous number of claims. And the claims in review proceedings are close to being frozen. And the reason why we say that is because a motion to amend is rarely sought because they're rarely granted. And so it's the hurdles that are there have thrown cold water on the interest by patent owners to file a motion to amend. It's far better to seek additional opportunities to amend claims through the filing of a reissue application or an owner-initiated ex parte re-examination. And of course, all of those options are limited to narrowing the claims unless you file a broadening reissue within 2 years of issuance. And those narrowing amendments are undesirable because they all trigger intervening rights. But that's, and of course that kills the damages, but the alternative of not having any patent protection is if that's your only option, certainly it makes sense to pursue those. So consider a reissue or re-examination if you're the patent owner. But the issue that the petitioner needs to closely consider with regard to whether or not the claims are frozen or fluid is what's in the specification that's not fully claimed. Is there something in the specification that would enable the patent owner to amend claims in a way that it narrows around the prior art reference, yet still covers the accused device? If so, any proceeding at the Patent Office is potentially very dangerous, and those rights are available for the patent owner. And so, when assessing the patent owner's position, keep in mind that it could shift.
Yeah, good point, Kevin. What about the number of arguments? This is another factor that does not make a difference in the analysis. In both forums, you are limited in the number of challenges you can raise for one reason or another. In AIA trials, there are page limits. You have a 60-page limit for an IPR petition. You have an 80-page limit for a PGR or CBM petition. And there's this redundancy doctrine that Kevin mentioned. Whether it's called redundancy these days or it goes by another name, the idea is that if you present multiple challenges, they will be evaluated by the PTAB for similarities. And if they are similar enough, the PTAB will not take them all up, but only a subset. So in light of those factors, we believe it's best to focus your petition on a few well-developed challenge grounds. I think 1 to 3 is ideal. This is far different from what happens in reexamination, where you can take a multiplicitous approach, and it's not uncommon to file a reexamination request with dozens of substantial new questions of patentability or proposed rejections. But that's just not an approach that works in the PTAB.
So the next issue is the effect of equities, which is especially interesting to a sociologist. The differences between the PTAB, which tends to be more inclined to decide things based on the technical merits, versus a court where you've got a jury which is much more likely to be influenced by other issues. And attorneys tend to compartmentalize issues. That's less so for the average juror. They tend to blur the issues and take everything in and also be influenced by the overall equity. They may be influenced by the presentation of the heroic inventor and evil corporate America thwarting that heroic inventor. Those kinds of storylines play well to a jury, but they're irrelevant at the PTAB. And so big picture issues just don't come through at the PTAB. They're going to decide things based on the technical merits. There's possibility of some institutional bias against a non-practicing entity, but there's no basis for such an assertion, and if that's a concern, certainly we're better off at the PTAB.
Yeah, to me, Kevin, this is a big factor, an important factor, and it explains why patent owners are so successful when it comes to trial. If a patent owner can get its case to trial, it's either going to get a favorable settlement or likely win the verdict. And that's why so much of defense strategy is aimed at avoiding trial one way or another. And the PTAB is a great way to avoid trial. You can get the case stayed. You can win in the PTAB in a more favorable forum. So I completely agree with you. Now let's talk about timing. Now it seems like a simple question to ask, well, which proceeding would finish first? But it's a very complicated one to answer. There are so many layers of complexity here. I'm not going to cover them all, but I will point out a couple things that are on the slide here. One is that the proceedings may not start at the same time. For example, with IPR, there is a 1-year bar. The IPR petition must be filed within the 1-year anniversary of the service of the infringement complaint. And that's not uncommon. So you don't have an IPR petition in some cases until almost a year after the litigation has begun. And then you have the issue of stays. It's not uncommon for courts to stay the litigation pending an AIA trial. We could do a whole presentation for an hour about stays. It's a fascinating subject, especially when it comes to CBMs, where stays are even more likely. So that complicates the timing analysis. And yet another complication is estoppel. And this has less to do with timing than it has to do with just the interrelation between the proceedings. And so maybe we should have put this on a separate slide, but we'll address it here. And the point is that, yes, there is estoppel. As soon as there's a final written decision in an AIA trial, the petitioner is estopped. The estoppel that applies in court in the case of an IPR or PGR is that the petitioner is estopped from trying to litigate the same challenges that were actually raised in the IPR or PGR or reasonably could have been raised in the IPR or PGR. And in CBM, the scope of that estoppel is a little bit, well, it's not as broad. It only affects challenges actually raised, not those that reasonably could have been raised. So you have this estoppel effect, but my point is that you shouldn't agonize over estoppel. Yes, it's there, and it means that as a practical matter, you're going to get one bite at the apple. And you need to take that bite in the forum where you have the greatest likelihood of success. And if it isn't apparent already, we believe that in most cases, that is going to be the PTAB.
Yeah, fortunately, the hand-wringing over estoppel seems to have diminished, although not with respect to post-grant review. But I think the interesting point that I think eventually litigators accepted on this issue is that if a case was litigated and then a killer piece of prior art is identified, it's very unlikely that anyone goes back to the executive team and says, hey, we found a reference that if we were to litigate again, this time we'll win. That's a practical estoppel that's probably more severe than the legal estoppel that you have at the PTAB. In terms of costs on slide 33, the costs for litigation review and reexamination differ by an order of magnitude. So litigation would cost several million, review proceedings would cost several hundreds of thousands, and a reexamination would be several tens of thousands. The standing issue is interesting. It's somewhat unresolved. There is no standing requirement to file a review petition or a reexamination request. And so that is appealing, but there is the consumer watchdog case that addressed standing for an inter partes reexamination. And that's, by analogy, has implications for review proceedings. So be aware that standing could be an issue on appeal, although in dicta that case indicated that so long as you're a competitor, you likely do have standing. Matt touched on the availability of reexamination to enable a challenger to remain anonymous. That's advantageous in circumstances where you have a friendly relationship, for example, between a customer and a supplier, and you don't want to disrupt that, but yet one party is using its patent position to extract an advantageous contract. So you need to be able to continue to do business in a friendly way, but maybe you want to do so on better terms. That is a limited circumstance where reexamination remains a compelling option. Since the institution of the AIA, the volume for reexamination has dropped more than below 50% of what it was prior to AIA.
Yeah, and Kevin, I should clarify back on slide 33, that first bullet point understanding is absolutely correct for IPR and PGR, but of course for CBM, there is a standing requirement. You must have been sued or been charged with infringement of a covered business method patent. All right, let's wrap this up. On slide 34, we list all of these factors we have discussed, and we indicate whether they favor the PTAB or court. And in my view, the important factors are the ones with the thumbs up under the PTAB column. The decision maker, the claim construction, the evidentiary burden, the discovery, the effective equities, and cost. There are some factors that favor the court, but in my opinion, those are usually less important factors, and the advantage that those factors afford in the court are usually not that significant. But that said, it's not necessarily true that every case is best brought in the PTAB. You need to look at your case on its unique facts and circumstances to make that decision, and we just offer these factors as something to perhaps guide your analysis so that it's thorough and well-informed. And one point I should make here is that we've assumed that success is actually invalidating the claims that you're concerned about, that you're targeting. But we should note that in a PTAB proceeding, or even in a reexamination, you can have a successful outcome short of a cancellation of the claims that you're targeting. For example, if you have prior art that closely resembles the accused instrumentality, then bringing a PTAB or reexamination challenge based upon that prior art can lead to a success even if the claims are confirmed, because in distinguishing that prior art, the patent owner may very well distinguish its claims from the accused method or device. So that can set up a nice non-infringement position. In other words, you're making the patent owner create a prosecution history through the post-issuance proceeding that sets up your non-infringement position.
That's a good point, Matt. I'd like to add that there are certainly differing views about these different standards and how big of an impact they have. I think that the most important consideration, I think the factor that most impacts outcome is the strength of your prior art references. And that relates to obviousness most typically. And because of that, PTAB proceedings are almost always the preferred option because of the ability to present a ground under obviousness that will be well understood by the three members of the panel.
Good point, Kevin. So I think we're actually finishing on time despite the technical difficulties at the beginning. We're happy to stick around longer and answer questions if people have questions. If not, our contact information is on this last slide, so feel free to contact us anytime. And as Pedro mentioned, you can learn a lot more about this topic if you come to our PRG course. That's April 10th through 12th in Tampa, Florida. We spend 2.5 days going through all of the nuts and bolts of AIA proceedings, many of the nuances and strategies, and we share our war stories. And it's in a nice resort location. It's a lot of fun.
So thank you so much, Matt and Kevin, for the interesting presentation. One question, like in terms of timing, can you tell, like, to reduce costs, overall costs for the company on the defense side, if a company gets sued, do you recommend that they start IPR immediately? Obviously, then there's two processes in parallel. One is the court, and the other is IPR, and they're burning money on both sides. Or they should wait and file like motion to dismiss, or like, what's your recommendation in terms of cost?
Sure. I'll take a stab at answering that. I think it is best to get started on an IPR strategy right away. The sooner you file that IPR petition and the sooner it's granted, the more likely it is that the court will stay the litigation. It's common for judges these days, district court judges, to wait until there is an institution decision. So that's typically about 6 months after you file your IPR petition. And so if you're concerned about minimizing the cost of litigation, you need to get your IPR petition on file as soon as possible. The one thing that may hold you up from doing that is you may not know which claims are asserted until you've litigated a while. But in a lot of cases, you know, or you can guess, and those are the claims you want to target in your IPR petition.
Yeah, I mean, that's a great point. Although, like, we've heard different arguments that in some, depending on the state, you know, the case may be stopped or not. Like some states is not as easy. Any comment on that?
Yeah, I think, again, the biggest factor for a stay is how early in the case is it. And you're right. I mean, some districts, like the Eastern District of Virginia, or Eastern District of Texas, or Virginia for that matter, they will look for reasons to deny the stay, maybe more so than other districts. But if you present a compelling case that we're early in the litigation and that there would be simplification by staying, then even those districts do grant stay motions from time to time.
There really is quite a bit of variability from district to district. The thing I've been most surprised by over the last couple of years, I really thought that the rate of granting motions for stays would increase because they do reduce the issues and they're resolved quickly. But I think that the Patent Office proceedings received such a bad reputation because of inter partes reexamination that a lot of judges have decided that you know, they really don't want to go that route.
Yeah, the stay rate for contested stay motions is about 60%. And that was true with re-exam in the past, and that's approximately true with AIA trials today.
Okay, thank you very much, Kevin and Matt. Very interesting presentation. And I would like to thank the speakers and also remind everybody that on February 25th, we have another webinar. It's about Alice by Chief Patent Counsel of IBM, Manny Schechter. He's going to talk about Alice and getting past Alice. So I would like to invite everybody to sign up. And again, our apologies for the technical difficulty. We will send a link to the full presentation, and hopefully everybody can watch it later. Thank you so much. Have a wonderful day. Thank you. Bye.